Okay, Mr. Trush, you have Mr. McLeod.
He is in the Crawford County Jail.
Oh. Is Mr. Hurd present, Mr. Brown?
Yes, sure.
People versus Jeffrey Hurd. This is case number 236607.
The record, John, much on behalf of Larry Brown, on behalf of Mr. Hurd.
Thank you. The record should reflect Mr. Hurd is present here in the courtroom today. This is set as a final status conference. It looks like we have trials currently set for May 28th. So today would be the plea cutoff. Mr. Brown, how do you and Mr. Hurd want to proceed in terms of trial?
Your Honor, I have had conversations with Mr. Hurd as well as Mr. Trush, who was his former counsel. At this point, there has been a plea offer in the matter, but at this point, we are going to proceed to trial.
Okay, so Mr. Hurd, you understand that today is the plea cutoff. That means this would be the last day to enter a plea in this case?
Yes, sure.
Okay, and with that in mind, is it your wish to proceed to trial?
That's fine. Can I speak before we go any further? If you're sorry.
Yeah, you might want to talk to Mr. Brown first.
I will talk to you.
Okay.
Despite all this nice, I know it's second time talking about that, but I don't think we should proceed any further at this moment because in my eyes, no offense to you, sir, me and him haven't really had a conversation about anything. Mr. Truce let my case go 2 months ago. I waited 4 days and then I reached out to him because they told me this is who my attorney would be. I reached out to him. It took him maybe a month and a half to get back with me. And then he said he went over my case. No, you went over what's on paper. You haven't talked to me or discussed anything with me. And then you expect me to come in here and just be okay with going further. I feel I don't have no personal problem against him, but I feel like he needs a little more time, please, Your Honor, if possible, if it's okay with you and the prosecution, because this is not fair, honestly. Like, I'm not gonna just sit here and get railroaded. And I know he hasn't had enough time, but when I seen him 5 days ago, I gave him paperwork he didn't even know existed on my case that Mr. Truce was supposed to send to him that he said he never received. So I don't feel like we should be pushing forward right now. I think we need to really, if it's okay with y'all, could he get a little more time on this? I don't know why he didn't come up here and say this, but I'm not, this is my life.
I understand. I mean, the trial is set for May 28th, so that's 6 weeks from now.
Okay.
So, I mean, in my view, that should be an adequate amount of time. This case was bound over last September.
Yeah, and I had Mr. Truce, my attorney, and then he dropped my case apparently of a conflict of interest. I didn't understand it was a conflict of interest and it didn't have anything to do with my case, but I don't control that stuff. So it was just a question. That's all.
Okay. Well, you've got 6 weeks now before your trial to talk to Mr. Brown. You know, if you've been having trouble communicating, I would consider, you know, setting this for one more status conference. If you want to further consider plea offers, since we do have 6 weeks.
I'm not doing plea.
Okay, so you do want to go to trial?
Yes. That's right.
All right. So again, in my view, 6 weeks is more than enough time for everybody to be ready for a trial in this case. So you want to talk to Mr. Brown further here before you leave today, so you can set up some dates and times for the two of you to meet so that you can get prepared to go forward. You're free to do that. But otherwise, Mr. Rolla, will the people be ready to proceed on May?
Yes, Judge.
Okay, so we'll proceed forward with the trial date. And Mr. Hurd, you know, if you're unhappy with your counsel, you're free to hire your own attorney at any time, of course. If you're unhappy and you want to request a different court-appointed counsel, there's a process for that as well. Mr. Brown can explain that to you. But if you want to do either of those two things, I would suggest you do those very quickly. Okay. All right. Thank you. That's all for today.
There was one more thing he was supposed to speak to you about, Your Honor. He's not saying nothing. I've been on this thing for 8 months. I haven't violated at all. I haven't done anything wrong.
That's good.
And no, I was only supposed to be on it for 30 to 60 days, apparently. Like, it's hindering me from work, all types of stuff. Like, I've been maintaining my job since I came home. Like,
So why do you want to push this out further then?
because this is my life and all this is just, Your Honor, I'm sorry. I haven't had no sleep. But again, last time I was here, Mr. Truce asked to get this off my leg. They said, he even stated and said, there's no evidence of me contacting this woman or nothing. It's a no contact order right on my paperwork. He said, I have been trying to contact this woman. If that's the case, why haven't you put a arrest warrant out for me? But I have proof that this young lady is trying to reach out to me. Why is this thing still on my leg? It's 8 months later. I haven't done nothing.
Your Honor, if I could address that, and that is correct, and I apologize. I was going to bring that up. I've had conversations with Ms. Van Wolfen, I believe it is. And she would not be opposed to having this tether removed. I thought she was going to be here today.
I'm here.
She's here. Okay. If she could speak to that, I think she would be in agreement to have that tether removed.
Judge, I don't know what the basis is for having the tether removed. If I hear it, then maybe I can comment on it, but I don't have that information.
He's just been on tether for 8 months now. Generally, people are, at least according to Ms. Van Wolfen, the rule of thumb is using them 3 to 6 months. He's not violated at all. He'll be on this, almost 9 months. It's going to be, he's not violated. He's never let the battery run low. I don't see the continued need for the tether.
Okay, Ms. Van Wolfen?
Yes, Your Honor. So generally, we try to use the least restrictive forms when in community corrections. He has complied the entire time. Once a trial date is set, we are then supposed to charge the defendant. I do know that he is working. I know that can be, it's about $5.50 a day for us. And I know that he has complied. He calls me every single week. I know where he's at all the time. I know exactly where the victim lives. He has not even gone in that direction because they do live in relatively close terms. So I wanted to bring that to your attention that we do try to be least restrictive once a trial date is set.
True.
Well, Judge, again, it's not just a matter of the defendant not currently contacting the victim. The question is we have a trial that's coming up on a very short trial date. It's in May. This isn't like it's an extended time period out. And we don't know that if his tether gets removed, that he's not going to specifically do that, especially in light of some of his comments I've heard on the record today.
I've been in this town 19 years. Where am I going? Every time I've had a court case, I've been at court.
Okay, all right, all right. Based on what Ms. Van Wolfen's indicated, the court will approve the removal of the tether. However, the no contact provision will remain in place. So all the conditions of your bond are going to be the same, Mr. Hurd, other than you won't have to deal with the tether part of it. But you still may not contact any of the individuals involved that are listed on your bond paperwork, okay?
Yeah, sure. Right.
Ms. Van Wolfen, does he need to check in with you to arrange for that?
Yes, I'll be headed back to my office.
Okay, so why don't you meet with Ms. Van Wolfen here before you leave the courtroom, and that's all for this hearing today. Thank you.
Thank you.
Okay, Mr. McLeod, are you able to hear me okay?
Yes, Your Honor.
Sure.
Mr. McLeod, just give me 1 second. Your attorney's making his way into the courtroom, okay? Mr. Truce, we have Mr. McLeod connected. So we're on the record in People versus Raymond McLeod, case number 236613. The record should reflect Mr. McLeod is appearing today by video from the Crawford County Jail. If I could have counsel put your appearances on.
For the record, John, am I going to ask people?
Your Honor, Richard Trish on behalf of Mr. McLeod. Your Honor, I think we are here with an agreement for the court.
Okay,
And that would be that Mr. McLeod would plead to. So I got identified with the counsel. But it would be a count of felon in possession of a firearm as a HAB 2 and the felony firearm count. And again, I believe that those would be 3 and 4.
correct. 3 and 4 is habitual second.
Correct.
Okay. All other counts are dismissed.
Correct. And I would indicate at the last hearing, we had this agreement in place, but we were waiting for Menominee to act. Mr. McLeod has pled a Menominee, and I believe he told me May 8th. Is that your sentencing date there?
May 10th.
I was close, May 10th.
Mr. Rolla, is that a correct statement of the plea offer?
I believe it is, Judge.
And Mr. McLeod, were you able to hear what Mr. Trush said about the plea agreement in this case?
Yes, Your Honor.
Is that how you wanted to proceed today?
Yes, sir.
Okay. Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can lower your hand. Mr. Trush, are you aware whether Mr. McLeod's status is going to be affected by the plea here today in terms of any kind of probation or parole?
I do not believe that he was on probation or parole at that time.
Okay. And are there any consecutive sentencing sanctions possible, bond status or anything like that?
That I'm not positive of. Mr. McLeod, were you on bond at Menominee when this offense occurred?
No.
Okay. All right, thank you. Mr. McLeod, do you understand that by pleading guilty to count 3, which is possession of a weapon by a felon as a second habitual offender, that the maximum possible penalty that you could face would be up to 7.5 years? Do you understand that?
Yes, Your Honor.
And then count 4, which is felony firearm, that again, as a second habitual offender, that the maximum possible penalty you could face would be up to 3 years.
Yes, Your Honor.
And do you understand that that charge of a felony firearm has to be served consecutive, in other words, back to back, with any penalty that you will receive for the other charge in this case?
Yes, Your Honor.
With all of those things in mind, what is your plea to each of those charges today?
Guilty, Your Honor.
Right now, you have certain rights. I'm going to go through those with you here on the record. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
Yes, sir.
You understand that you're giving up and waiving all of those rights by pleading guilty?
Yes.
Anybody threatened you with anything to get you to plead guilty today?
No, Your Honor.
Has anybody promised you anything other than what we've said here on the record?
No, Your Honor.
Is it your own free choice to plead guilty?
Yes.
And are you pleading guilty because you are guilty of each of these charges?
Yes, sir.
All right, the date that I have on the information here is back in September of 2023, on or about September 1st. Is that the right time frame?
Yes.
On that time, or during that time frame, were you present here in Otsego County?
Yes.
And while you were here in Otsego County, did you have possession of a firearm?
Yes.
And had you previously been convicted of the felony of uttering and publishing?
Yes, Your Honor.
Had you in any way had your right to possess a firearm reinstated after being convicted of that felony?
No.
Right, and I mean, counsel, do we need any further testimony, or does that testimony fit the facts for both charges here?
I think that testimony will provide a basis for both charges.
I believe that's correct, Judge. And as this is the have second, that's only other information I would require.
But I think he's already acknowledged the
Prior
Underlying
felony, so I think the court has sufficient factual basis to accept the pleas as to both counts. As in,
Okay. Mr. McLeod, you understand that you don't have any automatic right to appeal the plea that you're making here today, and that if you wanted to try to appeal it, you would have to ask the next higher court up, the Court of Appeals, to hear your case. And if they said no, that would be the end of any appeal of the plea. Do you understand that?
Yes, Your Honor.
Mr. Rolla, are the people aware of any other threats, promises, or inducements other than what's been placed on the record?
just that per statute, the firearm and ammunition has to be confiscated into that. But that's mandatory, Judge, so it's really not required to find a plea offer.
Thank you. Mr. Trush?
I would agree.
Mr. Rolla, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Judge.
Mr. Trush?
Defense is satisfied.
Mr. McLeod, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter, or of the both charges, the court will accept your plea as a whole. We'll set this matter for a sentencing hearing. Mr. Trush, is there a particular way that you'd like the court to schedule that, given this sentencing hearing coming up in nominee?
As close to the 10th as we can get it would be preferable, because the expectation is that he's going to be sentenced to prison.
Okay. Mr. McLeod, are you going to be transported to Menominee for sentencing, or are you going to do that from Crawford County there?
I'm going to do it from Crawford County.
Okay. The court is going to set your sentencing hearing here for the soonest possible date that we can. It's probably going to be after that sentencing hearing. However, you do have the right to be transported here to Gaylord for the sentencing hearing, to be here in person. And if you wanted to exercise that right, the court would sign an order to have you transported here. You can also waive that right, and we can do that by video, as you're going to do with the Menominee case. Do you know how you'd like to proceed on that?
We can do it by video.
Okay, so the court will set it for sentencing by Zoom, and we'll go from there. Mr. Trush, anything further on this case today?
I don't believe so, no.
Mr. Rolla?
No, thank you.
Mr. McLeod, did you have any questions at all?
No, Your Honor.
Okay, thank you. That's all for today, and the court's going to disconnect at this time. Is Ms. McHugh present?
Yes.
People versus Heather McHugh, case number 236647. Record should reflect Ms. McHugh's present here in the courtroom. Put your appearances on.
Record.
Thank you, Your Honor. Richard Church on behalf of Ms. McHugh.
This is a final status conference in this case. We have a trial currently set for May 30th. So Ms. McHugh, this is the plea cutoff. Mr. Trush, have you had a chance to speak with Ms. McHugh about that?
I have, Your Honor, and so I want to give the court a little bit of background, and then I'm going to make a request of the court. So as recently as Friday of last week, the prosecutor and I were discussing possible resolutions that has resulted in a slightly different offer being made. I had an opportunity to talk to Ms. McHugh about that a little bit this morning, and in a little bit before the offer was made, as we made a counter offer, and that's sort of how we got to that place. I would ask the court to set for us one more status conference, and I would indicate for the court, I understand that we're set for jury trial on the 30th and 31st. it seems incredibly unlikely that trial is going to go, as that's part of a 3-day trial with an incarcerated defendant, which seems a virtual lock to go at this point. Frankly, it's a second trial for that person. So I would ask the court for one more status conference, possibly in the beginning of May or even middle May. I think we're pretty close to having a resolution on this. Ms. McHugh and I just need to go over what the scoring will look like on the new offer so that we can make an assessment.
Okay, Mr. Rolla, any objection to that?
No, Judge, I would confirm that both Mr. Trush and I had both discussions and traded several, I guess, emails Thursday and Friday of last week.
Okay. So we'll set it for a plea hearing in May. I don't know if it'll be beginning of the month or the middle of the month, but I'm gonna leave the trial on as scheduled for the time being, with the understanding that there's a fair chance that it's gonna resolve prior to that. Ms. McHugh, did you have any questions at all?
Just asked him, so I'll receive the court date in the mail.
Correct, yeah, and just make sure that you stay in touch with Mr. Church so that you're ready with the decision on that day, okay?
Okay, thank you.
All right, thank you, that's all on that file. Our next case is People versus Ethan Gentz. Mr. Gentz is lodged in the jail, so as soon as we'll take a short recess, and once he's present, we'll Okay, we're on the record in People versus Ethan Gens, case number 236546. The record should reflect that Mr. Gens is present here in the courtroom today. That you have counsel put your appearances on.
Your Honor, my call back to people.
Thank you, Your Honor. Richard Church on behalf of Mr. Gens.
All right, this is the date and time set for sentencing hearing in this case. Mr. Gens, have you had a chance to go through the pre-sentence report and talk to Mr. Church about that?
Yeah. Actually, Your Honor, before we get too far down the rabbit hole, I would note that the alleged victim's not here. She had expressed a desire to speak at sentencing. So I suspect before we get too far, the prosecutor's going to request an adjournment.
Mr. Rolla.
That's correct, Your Honor. The victim specifically requested that she be available for sentencing as is a right under the Crime Victims' Rights Act.
Okay, and I do recall that from the previous hearing. So the court will, well, what do you take a position on that, Mr. Church?
So again, I think under the Crime Victims' Rights Act, she's entitled to do so. And I would even say sort of structurally how we get here, I think it's appropriate for her to be able to speak. And I say that in the sense of the background here is we were scheduled, I think, a week or two ago for this. But Mr. Gens got his dates mixed up. She was present at that time. This got set for today at our request because Mr. Gens was in the jail. So I think that's an appropriate way to proceed. Two housekeeping matters I do want to verify. First with the court, that the court did receive the risk assessment that we submitted.
Yes, I did. And I did have a change.
And then secondly, if we're going to adjourn, and it seems obvious at this point, I'd like to address bond.
Okay, I am going to adjourn it. I think it's a statutory issue. Mr. Gens wasn't here last time and the victim was, so really I think it wasn't a statutory issue. Fairness would require the court to adjourn this out so that the victim can be heard. So the court is going to grant the adjournment and then your request regarding bond.
Thank you, Your Honor. I would ask the court to consider reinstating Mr. Gens's bond. This is a situation where at the time of sentencing, Mr. Gens wasn't here. I was in communication with him. He had indicated to me that he had thought it was Thursday, not Wednesday. He got the date mixed up. I think that bears out in that he attempted to turn himself in Thursday. The warrant had not yet been processed, and I believe from my communications with him, he was planning to turn himself in on Monday. I think he got picked up over the weekend. But I can verify the jail staff confirmed for me that he tried to turn himself in on Thursday. I think he contacted the court staff as well. And frankly, I think he contacted the prosecutor. He made every effort to turn himself in. And frankly, I think was pretty concerned when they would not take him on Thursday, but the warrant hadn't been processed yet.
Thank you, Mr. Rolla.
Just for a few clarifications, Judge, it was a situation, as I'm sure the court is personally familiar with now, that the warrant was there, but again, as I understand, you were tied up in another county, so the warrant was assigned to the following day, and that was the reason for delay. It was, however, as I understand it, signed before 4 o'clock on that afternoon. Why the jail didn't have it, I don't know. I can't speak to that. As far as I don't know if the court's going to arraign on the bench warrant, if that's already been done. My notes don't reflect that, so I just ask about that for housekeeping purposes as well.
Sure. So when someone doesn't appear for sentencing, the court orders that the bond is revoked and that they be held pending sentencing because number one, they're no longer entitled to pretrial release. They pled guilty to a charge. Number two, in this case, I fully intend to sentence Mr. Gens to some jail time in excess of what it's going to take for us to get this reset. So in my view, there's really no basis to release him at this point. He'll be getting jail credit as he waits for the sentencing date. And yeah, so the court's going to deny bond. At this time, he'll continue to be held until the court can have this set for sentencing.
Understood. We just requested it be reset for the court's earliest available date.
Okay. All right. Thank you. That's all for today then.
Class said we ready, or actually, Mr. Cruz, do you have Mr. Ray present?
He is in MDOC.
Yes. Okay. They're not up yet. Mr. Clagstead, are you ready with your client?
Sure.
Okay.
Court calls People versus Jared Martin, case number 236620.
Record, John, I call that.
Judge Mike Clason on behalf of Mr. Martin.
This is the date and time set for a sentencing hearing in this case, and Mr. Martin, you had a chance to go through the pre-sentence report and talk to Mr. Flagstead about that.
I have, Your Honor.
Flagstead, are there any additions, deletions, or corrections that need to be made?
None for the defense, Your Honor.
And any challenges to this according to the guidelines?
None from the defense, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No additions, lists, or corrections to the body of the report, nor challenges as to this guideline.
Anything on behalf of the people for elocution today?
Well, Judge, this is a situation where we're dealing with a person being apparently accepted into another jail court, a drug court program. That kind of pretty much, for lack of a better term, ties pretty much the court's hands on what you're going to be doing in sentencing. But for that circumstance, people would have been saying that in a situation of a fourth felony with a second drunk driving third, it's not exactly a matter where the people think that no jail time should be imposed up front, especially since I believe last time around, I think he got, I want to say 11 months perhaps on his left. Yeah, 11 months back on August 20th, 2019. Thank you, Judge.
Thank you, Mr. Flagstead.
Judge, I can't offer an excuse for the conduct that brought us here because there isn't one. What I can say is that since I met Mr. Martin sitting in my office, he's come a long way. Even his body language is different. Hearing him work through the process, starting from square one, detox, and actually getting to AA, working the steps, talking about the steps, I'm optimistic, Judge. I think he understands that he's at the end of his rope here. And moreover, Judge, I think he's climbing, which, you know, he's really only got two choices at this point, and thankfully, I think he's making the right one. I do think he's going to take advantage of this opportunity. All I can hope for him is that this is lasting change and he's never in a courtroom again.
Great, thank you. Mr. Martin, anything you wanted to say today?
Yes, Your Honor. I've the program I was in at Harbor Hall is a very great program. I've learned a lot there about myself. It's, I mean, hands down, just one of the best places I've ever been to. Willingly making the change to better myself. And I want to thank you for the opportunity, because I've never had the opportunity to attend sobriety court. That's it.
Okay. I did read through the report. I'm familiar with your background and your circumstances personally, as well as your prior criminal history. I'm familiar with the facts of what happened in this particular case as well. And I think what Mr. Clagstad said is exactly right. I mean, you're really at a point now where you only have two options. Either participate in and successfully complete the sobriety court program, or be incarcerated, because you know, from our standpoint in the community, we can't allow you to continue to engage in this behavior, because sooner or later there's going to be a catastrophic result to it. So I hope you do take advantage of this opportunity, because it really is, and it's not going to be easy. It's a very difficult program. I presided over a sobriety court for a number of years, and there's a lot of requirements, and you really got to toe the line. But the benefit to you, aside from avoiding more jail, is getting yourself in a position where you can go forward in life, be more productive, and not have this become a recurring problem. Benefit we get from a community standpoint is now we have somebody who's sober, who's not out there causing problems and being a danger to everybody else long term. Jail is a short-term solution. This is a long-term solution for the community, and that's why I think it's a good option, and I think it's worth giving you the opportunity to do that. On the other side of it, of course, if you don't, it is the consequences. So I think the recommendation is appropriate. The court is going to follow it. The court is going to sentence you to probation for a period of 3 years. The court is going to adopt as the terms and conditions of your probation all of the terms and conditions that are listed in the report. So it's important for you to go through all of that with your probation agent. Also, the most important condition of that is that you participate in and successfully complete complete the Sheboygan County sobriety court program. The court is going to impose 12 months in the Otsego County Jail with credit for 2 days served. The court's going to hold that time in advance to be used at the discretion either of the sobriety court or if jurisdictions returned here of this court. The court is going to order that you pay a OUIL reimbursement fee of $200, a state cost of $68, crime victims assessment of $130, a supervision fee of $30 per month while you're on probation, court costs of $325, as well as any fee required by the Sheboygan County sobriety court program. And that is all as to count 1. As to counts 2, 3, and 4, the court sentences you to $150 state cost. That's a total for all 3 of those counts. You do have the ability to seek an appeal of this sentence, and Mr. Flagstad, if you can have Mr. Martin initial indicating that he's received this. All right, and Mr. Flagstad, do we have the paperwork yet for transferring jurisdiction, or are you going to provide that later?
Judge, I was just looking, unfortunately, I only have our signatures, I apologize, I don't think that we have received Sheboygan County signatures, but I'd be more than happy to proffer that to the court.
Okay, yeah, we need to get that taken care of, and then Mr. Martin, it's important that you contact Mr. Brunical. He's going to be your supervising agent, at least for the time being, following court today. Mr. Roll, anything further that we need to address?
No, Judge, the court just addressed the one issue I was concerned about, that our offset got me copies of paperwork.
Mr. Flagstad, anything further?
Just one, Judge. The paperwork we did sign, the memorandum of understanding indicates that fines, costs, et cetera, are payable to Sheboygan County. I just wanted to make sure we're all on the same page about that.
Right,
Okay.
yeah, once the jurisdiction's transferred, it's no longer this court's case.
Got it.
Yeah.
Understood. Thank you, Judge.
All right, good luck to you going forward, Mr. Martin.
Thank you, Your Honor.
All right, sir, is your name Christopher Ray?
Yes, sir, Your Honor.
Okay. All right, we're on the record in People versus Christopher Ray. This is case number 246702. The record should reflect that Mr. Ray is appearing today by video from Department of Corrections. And if I could have count of your sign in this file.
For the record, Your Honor, my call behalf of people.
Thank you, Your Honor. Richard Kirsch on behalf of Mr. Ray. And I apologize, Your Honor. Prosecutor and I could have just a moment. I think we have a deal in place. So we're just finishing touches on it.
Okay. Is that gonna, do you need a break long enough for us to go off the record, or are you talking about a really short discussion?
It might be best to just take a moment off the record. I don't think it'll be terribly long, but.
Okay. All right, we'll take a short recess. Mr. Ray, we're just gonna keep you on hold for just a moment while the lawyers talk, and then we'll get started with your case, okay?
I can't, it's going in and out, I can't hear.
Okay, we're gonna take a short break, and then we'll come back and proceed on your case, okay?
Okay, yes, sir, Your Honor.
Okay, we're back on the record in People versus Ray. You know what? Can you grab the file? I left the file.
Absolutely.
Thank you. Again, Mr. Ray is appearing today by video. And do we have a resolution, Mr. Church?
We do, Your Honor. So just to give the court a little bit of background, Mr. Ray had 2 contemporaneous charges. One of them is obviously already taking care of itself. That's why he's in the OC. We were working out a deal based on those changing circumstances to try to not change his earliest release date. His current earliest release date is in 2029. And we do have an agreement which we do not believe is going to change his earliest release date. So that would be that he would tender a plea to an added count 4. That would be delivery of a narcotic less than 50 grams as a habitual second offender. That takes it from the B grid to the D grid. And the PAC code for that is 333-740-12A4.
Okay, and what's the maximum penalty for that charge
20 years, Judge.
with the habitual?
With the habitual action would be 30 years, correct.
Mr. Roll, is that a correct statement of the offer?
I'm just checking the PAC code now, Judge. That's on the 333-740-12A4, correct.
Mr. Ray, were you able to hear that?
No, it's really choppy, Your Honor. The audio is really choppy.
Okay, the plea offer in this case is for you to plead to 1 count of delivery of a narcotic as a habitual second, and all the other charges and enhancements would be dismissed. Is that your understanding of the plea agreement?
Yes, sir, Your Honor.
Is that how you want to proceed today?
Yes, sir, Your Honor.
Okay, can you raise your right hand?
Yes, sir.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do, Your Honor.
Okay, thank you. You can lower your hand. And I know you said there's problems with the audio, so if there's anything that I say that you're not able to hear or you need me to repeat, just ask, and I'm willing to do that, okay?
Okay, yes, sir. Thank you, Your Honor.
So as we said, the maximum possible penalty that you could face for this charge would be up to 30 years. Do you understand that?
No, I couldn't understand you, Your Honor.
Okay, so the maximum possible penalty that you could face by pleading guilty to delivery of our narcotic as a habitual second is up to 30 years. That's the maximum possible penalty. Do you understand that?
Yes, sir, Your Honor.
With that in mind, what is your plea to that charge today?
I plead guilty, Your Honor.
So I'm going to go through your rights with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. Do you understand all those rights?
Yes, sir, Your Honor.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
What was that, Your Honor? I'm sorry.
You understand that you're giving up and waiving all of those rights by pleading guilty?
Yes, sir, Your Honor. I do.
Okay. Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask the Court of Appeals to hear your case. They could say no, and that would be the end of any appeal. Do you understand that?
Yes, I do.
Has anyone threatened you with anything to get you to plead guilty?
No, sir, Your Honor.
Has anyone promised you anything other than what we've said here today in court?
No, sir, Your Honor.
Is it your own free choice to enter this plea today?
Yes, it is.
Are you pleading guilty because you are in fact guilty?
Yes, sir, Your Honor, I am.
The date that I have for this is back in December of 2023. Is that the correct time frame? Or January of 2023? I'm sorry.
Yes, sir.
At that time, were you present here in Otsego County?
Yes, sir, I was, Your Honor.
At the time that you were here in Otsego County, did you have possession of a controlled substance?
Yes, I did. Yes, sir, Your Honor.
And did you give or sell that to someone else?
I gave it to somebody else. Yes, sir, Your Honor.
Did you have any legal right to do that at that time?
No, sir, Your Honor.
Had you previously been convicted of possession, hold on. Back, all the way back in 2008, had you previously been convicted of possession of a controlled substance back in Saginaw County?
Yes, sir.
Thank you, Mr. Roller. Are the people satisfied with the factual basis?
Judge, I believe, Mr. Trush and I, have one more question we want to have asked the court. I think Mr. Trush is going to ask his client.
Okay, go ahead, Mr. Trush.
Mr. Ray, can you hear me okay?
Yes, sir.
The judge asked you if you were in possession of a controlled substance and if you delivered that. The substance that you delivered, was that methamphetamine?
Did I deliver it?
Yes, the substance in question, was that methamphetamine?
Yes, it was methamphetamine. Yes, sir.
I just think we needed to establish the higher in order to take the plea to the lower charge.
Sure, okay, thank you. Mr. Roller, are the people satisfied with the factual basis?
Yes, Judge, and the court's complied with the court rule in acceptance of pleas in this case. Also under the court rule that allows the court to accept a plea to a lesser offense after a basis for the higher offense is placed on the record.
Thank you, Mr. Church.
We are satisfied the court has complied with court rule. Court has an adequate factual basis, and I'm aware of no threats, promises, or inducements.
Thank you. Mr. Ray, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of this charge, and the court will accept your guilty plea. Mr. Ray, you have the right to have your sentencing hearing here in Otsego County. And if you wanted to do that, I would sign an order to have you transported here for that hearing. You can also waive that right, and we can have that hearing by video as we're doing today. Do you know how you'd like to proceed on that?
We can do it on video if you want, Your Honor. That's fine.
Okay, so the record should reflect the court will set this for a sentencing hearing by Zoom, and that Mr. Ray has waived his right to an in-person hearing. Mr. Ray, do you have any questions at all?
He said that the sentence would not change my ERD, correct, Your Honor?
Yes, that is my belief based on what your guidelines range is and when your ERD is.
And again, Judge, for the record,
Yes,
that's
sir.
not part of the plea agreement because we don't know how they're going to swear them out.
Right.
Right, and Mr. Ray, you do understand the judge ultimately fixes the sentence. We're just talking about what your guidelines range will be.
What my guideline range will be.
So, Mr. Ray, I'm going to set up a call here to talk to you in just a little bit. So you'll probably hear from me maybe next week, okay? And we'll talk about that again. So what the sentence looks like.
Is it gonna be what we talked about?
Yes.
Okay. Yes, sir.
Okay, thank you. That's all for today, Mr. Ray. The court's gonna disconnect at this time.
Okay, thank you, Your Honor.
All right, People versus Scott Munzel, case number 246678.
American John, I call them the people.
Larry Brown on behalf of Mr. Munsell.
Mr. Munzel, it sounds like we had some problems with you completing your PSI process. So what's the deal?
So originally, I had a transportation issue, so I rescheduled. And when I rescheduled, the first person I talked to told me if that day didn't work out, to just let him know, because I wasn't sure if my vehicle was gonna be ready by then. And I called to do that again, to reschedule, and the second person I talked to didn't seem like that was okay with them. And when I asked them if I could reschedule it or not, they said they didn't know and that they would call me back. And I never heard back. I guess I didn't realize that had been done before sentencing. I've never done this before, so that's my bad. I didn't realize that was much of a thing.
So I'm gonna have you meet with Ms. Davis here before you leave the courtroom today. If they're asking me to revoke your bond and put you in jail right now, I'm gonna give you another opportunity to comply with the process. If you don't, that's exactly what's gonna happen though. So whatever you need to do to be clear on what they want from you, that's gonna be on you. It's not up to them to figure out your life and getting you there. That's up to you to do that. So I'm gonna give you one more chance to do that. If you fail to comply next time, the court will either issue a bench warrant or maybe next time the court will have you arrested, so then we know where you're at and we know we can get it done. Okay,
We'll get it done.
all right, thank you.
Your Honor,
Yes,
just for the record, because I have not had any communication with Mr. Munsell, if he would put his address, make a phone number on, just to make sure everybody knows it.
Here.
have you been getting mailings from the court?
Yeah, I got mail.
Okay, so your address,
7713 Valley Road. That's
I just
Rapid
got a new
City.
number and I didn't even think that he didn't have it.
so make sure that Mr. Brown has it. Okay,
Thank you.
and we'll reset this for a sentencing hearing. Mr. Or Ms. Bruker, do we need more time for Bella sentencing, or are we ready to go? I don't know if you have victims that want to address the court or know that it has a schedule.
Mayor, here, Judge, I thought that Cindy Schrader from juvenile court was going to be here in case the court wanted to hear her at all. I don't see her yet, but I'll leave that to the court's discretion whether the court wants to wait.
All right, well, I want to make sure that everybody who needs to be here is here, so we'll take a short recess. That's scheduled to begin at 10:15, so we'll come back on the record right at 10:15. Mr. Ingersoll, are you able to hear me okay? Okay, and we've got your attorney connecting. Mr. Hallman, are you able to hear me?
I can hear you now, Judge. I didn't hear anything before this.
So what I have on the docket here today is file number 236657. The record should reflect Mr. Ingersoll's present by video from Roscommon County Jail. Mr. Hallman, his attorney, is present by video as well. Mr. Roller, are you handling me?
Yes, Judge, for the record, Your Honor, my call on behalf of the people.
Mr. Truce, are you involved in one of these?
Yes, I'm involved in 2 of them.
Oh, Judge, I apologize. Actually, Ms. Brooker is handling this one.
Okay, so I only had the 1 file docketed. Are we addressing all 3 files though today?
I think we did have all 3 docketed, just one I think is at 10:45 and the others maybe at 11.
Okay, got it. Okay, so Mr. Truce or Mr. Hallman, how do you guys want to proceed today?
Your Honor, I would like a moment to talk to my client in a breakout room. I don't know how this will work logistically for Mr. Truce. If he can step into the same room, or maybe we can 3-way him in there. But I would like to talk to my client, Mr. Ingersoll, just briefly. I haven't had a chance to talk to him since yesterday.
Did you want to sign in and go into?
I can go do that.
Okay, so Mr. Truce is going to sign in to Zoom, and then I'll put all 3 of you into a breakout room, okay?
Thank you, Your Honor.
That's just going to take a minute here.
Sure.
Okay. Okay, I'm opening up that breakout room right now. Mr. Brown, were you ready with Ms. Wells Kibbe?
Yes, sir.
Okay. We'll call People versus Deborah Ray Wells Kibbe, case number 246680. Record should reflect defendant's presence here in court today. I get counsel for this.
Thank you, Your Honor. For the record, my call on behalf of the people.
Very wrong on behalf of Ms. Wells Kitty.
Mr. Brown, how do we want to proceed on this file?
Thank you, Your Honor. I've had conversations with Ms. Wells Kibbe, as well as reaching out to the prosecutor just yesterday. Based upon the information that I have right now, we are going to have the matter set for trial.
Okay. Mr. Rolla, do the people need any particular period of time to be ready for a trial?
Not specifically, no, Judge.
How many days of trial do you think we'll need?
Well, in this particular case, we only have 4 witnesses. We can probably get it in a 1-day trial.
Mr. Brown?
Given what I know about the case, I think that would be sufficient.
Okay. So we'll set this for a 1-day jury trial at the court's next available date. And pursuant to the court's usual policy, we'll set this for a final status conference prior to that trial date. Mr. Roller, are there any novel legal issues involved in this case that are going to need hearings prior to trial?
I don't believe so, no, Judge.
Mr. Brown?
No, Your Honor.
So, Ms. Kibbe, the next hearing will be shortly before your trial date. The court will send you a notice of the date and time of that hearing, as well as the date and time of your trial date. It's important between now and then that you stay in touch with Mr. Brown. That final status conference prior to your trial will be the plea cutoff. So if there are any plea agreements, they would need to be entered into no later than that date, okay? To the extent that either side has any motions, that final status conference will also be a motion cut off. Mr. Roll, anything else that we need to address for the record on behalf of the people today?
Not in this case, thank you.
Mr. Brown?
Nothing further, thank you, Judge.
Ma'am, do you have any questions about how we're gonna proceed with the case?
No, yeah.
All right, thank you, that's all for today.
People versus Ryan Matos Solaris, case number 246700.
Record, Your Honor, microphone back to people.
Henry Brown on behalf of Mr.
Record should reflect the defendants present here in court today. This is set for a status conference. Mr. Brown, can you tell me where we're at?
Yes, Your Honor, there has been an offer made in this matter to plead to both counts for dismissal of the habitual notice. And we're going to take advantage of that today.
Mr. Rolla, is that a correct statement of the plea offer?
Actually, Judge, we plead to count one, but.
Oh.
But again, that's what I have. I'll take count one, the possession of a weapon for dismissal of count two in the habitual section.
No objection.
Okay, sir, you had a chance to speak to Mr. Brown about this plea agreement?
Yeah.
You need more time to do that, or are you ready to proceed?
No.
Oh, and, can I have you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Thank you. Sir, are you currently on any, you can lower your hand, thanks. Are you currently on any kind of probation or parole?
No.
You understand that the maximum possible penalty you could face for count one, which is possession of metallic knuckles, a weapon, is up to 5 years and or $2,500 fine. You understand? With that maximum possible penalty in mind, what is your plea to that charge today? Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial to question those witnesses. You have the right to have the court order any witnesses on your behalf here at trial. You have the right to remain silent during the trial and to not have that silence used against you. You have the right to testify at a trial yourself if you want it. You understand all of those rights. You understand that you're giving up and waiving all of those rights by pleading guilty. That's the honor. Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you have to ask the next higher court up, which is the Court of Appeals, to hear your case. If they said no, then that would be the end of any appeal. You understand that? Has anyone threatened you with anything to get you to plead guilty? No. Has anyone promised you anything other than what we've said here in court today? Is it your own free choice to plead guilty? Are you pleading guilty because you are guilty?
Yes.
This happened back on October 14th of 2023, is that correct?
Yes.
On that date, were you here in Otsego County?
Yeah.
And do you have possession of some brass knuckles or metallic knuckles that are a weapon?
Yes, I do.
Okay. Did you have any legal right to possess that type of weapon at the time that you had it?
I guess not.
Do you have any kind of permit or any other? No. Mr. Rolla, are the people satisfied with the factual basis?
I just didn't prevent you, Judge, but I may have missed that.
We did get that.
Okay, then, thank you.
Okay, Mr. Brown?
I am satisfied, and the court has also complied with statute for rule for taking pleas, and I am unaware of any promises, threats, or inducements outside of the record.
People also satisfied the court's complied with court rule statute as to the acceptance and aware of the threats, promises, or inducements not to accept the record.
Sir, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge, the court will accept your guilty plea. You're going to meet with Ms. Davis here before you leave court today to set up a pre-sentence interview. And then the court will send you a notice of the date and time of your sentencing hearing. Prior to that hearing, it's important that you stay in touch with Mr. Brown so that you're prepared to go forward on that day. Okay. Thank you.
Thank you.
People versus Brian Murphy, case number 246706.
The record, Your Honor, my own, yeah.
Larry Brown on behalf of Mr. Mertz.
Is that correct? Yes, sir. Oh. Mr. Brown, how did we want to proceed on this case today?
Your Honor, this was originally charged and then there was a subsequent amendment in which there was a habitual third offense notice added to this. There was an offer to plead as charged for dismissal of the habituals. I spoke with Mr. Murphy about that a couple of days ago. I believe we are going to take advantage of that offer.
Okay, so just count one with no enhancements.
It would be a second offense, I believe, but
Okay.
no enhancements.
No habitual.
No habituals, is that correct? That's true.
It's offered count one to dismiss the habitual third with the restitution of $600, correct?
Okay. Mr. Murphy, have you had an opportunity to speak with Mr. Brown about this plea agreement?
Yes, sir.
And is that how you want to proceed today?
Yes, sir.
Could you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Mr. Murphy, yes.
I apologize, Your Honor. I just want to make very clear for the record that it's count one as a subsequent offense, or is it just count one?
It's count one as a subsequent
Okay.
offense, correct.
Thank you.
But with dismissal of the habitual third.
Okay. And
And restitution of $600.
that's what I thought it was, Your Honor. I just want to make it really clear.
Mr. Murphy, are you currently on any kind of probation or parole?
This bond.
Just bond, okay. And you understand that by pleading guilty to count one, which is embezzlement of $200 to $1,000, that is a felony that carries with it a maximum penalty of up to 5 years and or a $10,000 fine or 3 times of the amount that was taken. Do you understand the maximum possible penalty?
Yes, sir.
That in mind, what is your plea to that charge today? Guilty. So right now you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial, to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, sir.
You understand that you're giving up and waiving all of those rights by pleading guilty?
I do, sir, yes.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and that would be the end of any appeal. You understand that? Has anyone threatened you with anything to get you to plead guilty? Has anybody promised you anything other than what we said here in court?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
This happened in December of last year, December of 2023. Is that the correct time frame?
Yes.
And at that time, were you working at Walmart here in Gaylord?
Yes, sir.
And did you take some money or property from Walmart during the course of your employment there?
Yes, sir.
And was that at least $200, but less than $1,000?
Yes, sir.
Did you have any permission or right to take that money or property?
No, sir.
Had you previously been convicted of embezzlement here in the district court in Otsego County back in 2007?
Yes.
Thank you, Mr. Roller. Are the people satisfied with the factual basis?
People satisfied with sufficient factual basis to accept the defendant's guilty plea to count one were, of course, comply with court rule statutes, for sentence of pleas and were aware of no threats or promises or other abuses that place not the represent.
Mr. Brown.
I agree with all the prosecutors.
Thank you. Mr. Murphy, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied that there is a factual basis to support a finding that you are guilty of that charge. The court will accept your plea. You're going to meet with Ms. Davis here before you leave the courthouse today to set up a pre-sentence interview. And then the court will send you notice of the date and time of your sentencing hearing. Prior to that, it's important that you stay in touch with Mr. Brown, your attorney, so that you're ready to proceed on that day, okay? Okay. All right. Thank you.
Your Honor, I believe that is my warning. And with regard to Mr. Ingersoll, Mr. Hallman and Mr. Trush's matter, I'm not sure if they're not back. It appears it was a jury trial to begin on May 30th. I have a jury trial with Judge Hunter on the same day. I didn't know if the court meeting was going to go at this time.
I don't.
I'll check that.
Okay. I'm not sure what's going to happen in Mr. Ingersoll's case today, so. The party's ready on Mr. Ellert's case.
Yes, Judge.
On the record in People versus Dylan James Ellert, case number 236520, 6521, 6522, and 6523. The record should reflect that Mr. Ellert's present here in the courtroom today. If I could have counsel with their appearances signed.
Thank you, Your Honor.
Mike Barnish on behalf of the defendant, Your Honor.
All right, and Mr. Bardish, I did receive your sentencing memorandum. I had a chance to review that prior to the hearing today. And so I know that there are some corrections to the PSI. Mr. Rolla, did you review the memorandum?
I did, Judge.
Do you have any objection to any of the corrections?
That's the body of the report, no, Judge.
Okay. So the court will have the PSI amended to reflect the changes that you requested, Mr. Bardish. Other than that, and what's in the brief, are there any other corrections, additions, or deletions there?
No other corrections, deletions, or additions, Your Honor.
Are there any challenges to the scoring of the guidelines?
None from the defense, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Your Honor.
Have any challenges to the scoring?
As to scoring, no, Your Honor. Thank you.
Do you have any victims that wish to address the board?
We anticipated one, but apparently not, Judge. We will choose to speak.
Okay. Anything on behalf of the people for allocution?
Judge, I had originally prepared a elocution report after reviewing the PSI. Received the defendant's sentencing memorandum. I feel now frankly more compelled to give further information to the court. In the defendant's sentencing memorandum, they tried to portray the defendant as a emotionally diminished 28-year-old with mental health issues, when the defendant is actually an accomplished con artist who over a period of over 14 months, and that would be from a time period of November 24th, 21, November 24th, 2021 through January 6th, 2023, committed a methodical and one-man crime spree, causing not only damage to the individuals directly involved, but also to our local community as well. He's being sentenced on 5 felony counts, which are actually his second, third, fourth, fifth, and sixth felony convictions. While it may be true that over the time period, and now, and I would acknowledge for the record, the defense, pursuant to the party's plea agreement, did provide a restitution check to our office, which we received today, that will compensate many of the victims. Quite frankly, Your Honor, doesn't make the victims whole, as this court's well aware, having been involved in many of these cases in the past, because while it gives them back to where they would have been had the crime not been committed to the extent that they're reimbursed for the losses at that time, it doesn't come close to dealing with what they've had to go through with the long delays that have taken place in this case. There are recommendations in this case where we're talking 1 year in jail with 2 days credit, up and down the line. This is a defendant who already personally received the benefit of HIDA back in prior incident, as indicated in his PSR. The defendant, in fact, is a financial predator. He exploited his victims to do the offenses he committed. And we would simply ask that the court by its sentence not reflect that he's again allowed to exploit this court and or con this court and his victims any further. Thank you, Your Honor.
Okay, Mr. Dardish, anything on behalf of Mr. Eller for allocution?
Yes, Your Honor. I think sentencing memorandums are always a delicate tightrope sometimes to walk, for lack of a better word. And I'm not, and I try to make it abundantly clear that we always have an obligation as a defense attorney to present, you know, the characteristics of the defendant. We're not trying to make excuses. And I think I peppered that throughout the sentencing argument. I'm not trying to make an excuse. I'm not. But I do feel like I have to point out that, you know, when we talk about every defendant being an individual, Dylan is an individual, and Dylan has suffered, or not, I don't want to use suffer, I'm not trying to overplay, but Dylan has had to overcome, I think, some challenges maybe than other typical people do not do. We are, the interesting thing I think about Dylan's condition is I think sometimes being on the autism spectrum, you are very capable in certain things, and then you are easily overwhelmed in other aspects of your life. And then when people get overwhelmed, people make poor, morally, I think, ambiguous choices, especially when you are panicked and you're dealing with gambling addictions and you're just trying to keep your head above water. It doesn't excuse the actions. It does not, you know, make the pain or the anxiety that was suffered by the victim in this case any less. I'm not trying to downplay that in any way. I'm also pointing out, I'm not trying to tell you that we've made them whole. I understand, and Mr. Roll is right, there is kind of intangible things that people suffer when they lose finances. So I'm not trying to in any way diminish that. I think what I'm trying to do is that Dylan has done everything he can, I think, with regards to the restitution aspect to make, I guess, financially the people whole as best that he can. And I think that is noteworthy. I think I've handled lots of financial crime cases, and there are ways to, especially in a case like this, not make them whole right away and simply put them on a payment plan. And sometimes people will use that argument, don't send them to jail, let him keep his job so he can continue to make the payments. But it was important, I think, from our perspective, that this has gone on for a long time. And I know that there's been missteps through the whole judicial process that we're trying to come to a finality, at least as far as the victims are concerned. And that was our main goal here, which is why we did a restitution payment in full, and that was written today. I guess what I would ask that this court consider is that, obviously Dylan has made a number of mistakes here, and he's made a lot of poor choices that I know he regrets, but he is on the path, I think, to atoning for those. And I think a big step was, emptying out basically everything he had to make sure restitution was paid in full here. And I think that's a good first step, because it's kind of putting your money where your mouth is, for lack of a better word. So that's what we'd ask. We asked that the court consider that sentence, and I know that the recommendation here is for 12 months. I'd ask if the court wants to use a term of probation, a carrot and stick approach. I think we would ask for something to that extent, hold some of the sentence in suspension to see how he continues to do. But in the end, I know that there is a tremendous amount of regret on his part. He knows that he made very poor choices. He made very morally poor choices, and he's trying to rectify that. One of the things he is doing is he is in Gamblers Anonymous. The gambling addiction doesn't excuse the behavior. There's plenty of people who have gambling addictions who haven't committed crimes. But he is chairing meetings, and he's using kind of what he's done to talk about this is where things can go. So I just think that goes in the whole step of trying to start atoning for things. Thank you, Your Honor.
Okay. And I do want to clarify one thing with counsel. So the court does not need to order restitution. Or that's been paid.
No, Judge.
Okay. All right. Just wanted to make sure. Mr. Ellard, anything that you wanted to say?
Yes, sir. Thank you, Your Honor, for allowing me to speak tonight. I want to start by apologizing to the people who have suffered as a result of my actions. I'm so very sorry for what I did and the stress and anxiety I am sure it caused every single person. It's difficult to look back at myself during this time period. Financially, I was in a very bad place and was too proud to reach out to the people who loved me for help. I was overwhelmed and used that as an excuse to make morally poor decisions. I'm ashamed and I'm extremely sorry for the pain I caused. I want to do better. I really do. My parents loved me and gave me the greatest gift of all by adopting me and bringing me to this country. If not for them, I'm 100% when I say this, I would be dead. And I know I apologize, Your Honor. I know I brought shame to a lot of people, especially for them. I also am sorry for how I behaved during this process. Sometimes you can get so overwhelmed that you're hoping to avoid the problem that will, I apologize. Sometimes you get so overwhelmed that you hope that avoiding the problem will make it go away. That was extremely disrespectful to the court, the prosecutor's office, and the victims. Again, I'm truly sorry for that. Again, I want to be better. I want to atone for my actions to be a better man. A man who my parents can be very proud of. I have let so many people down. I'm currently employed. I have advised my employer about the situation, and they have continued to let me provide and prove myself. I have taken a leave of absence as of last week because at the end of the day, I want to make sure that I can go back to them on good terms. Another recommendation is 12 months. I would love the opportunity to prove myself to this court with a possible lesser sentence, but again, I will leave that in Your Honor's hands. Thank you very much.
All right, thank you. I did read through the report, so I'm familiar with all the information in the pre-sentence report. There were some support letters that were submitted on your behalf. And of course, I read through, Mr. Bardish, your sentencing memorandum, and it did come across to me like you were trying to make excuses. And I thought you did a really good job of pointing out some of the deficits that Mr. Eller has, which I think are legitimate and real. And there's no question in my mind that you got some diagnoses that affect your behavior. And so, as far as you can, I thought you did a good job of pointing that out as a way for the court to understand how this situation came about. And so, looking at all of that as a whole, it does provide the court with some kind of explanation for perhaps why you did some of the things that you did. I don't think it is an excuse, and anybody even on your side is saying that it is, because the people that were victimized by you were clearly affected, and I read through their victim statements. And the thing that comes through with that is not just the financial losses, the lawyers pointed out, but the personal effect that it has when somebody feels like they've been conned or taken advantage of. They feel really bad about themselves. They're like, how could I be that dumb? How could I let somebody do that to me? And that's where the non-financial impact comes in, and that came through very clearly to me. And those folks, maybe they would have some sympathy for you because of your conditions, but certainly that doesn't diminish the effect that your actions had on these people at all. And that effect is real, and it comes through, and you need to pay a penalty for that. I also know that this isn't your first go around in the criminal justice system. You've had a couple different terms on probation, so you've had an opportunity to recognize some of the behaviors that you engage in and to take steps to correct those things. And you've been given an opportunity by the court in the past to do that, and you continue to engage in the same conduct over and over again, which is concerning to me because clearly you recognize that you've got some issues. You recognize that it's caused problems for you in the past, and you haven't taken steps to correct. My turn now. And the court also looks at progressive discipline. And as you continue to engage in wrongful behavior and hurt other people through your behavior, this isn't a victimless crime, there are victims here. The court ramps up the penalties because clearly what's been done in the past hasn't gotten through. And so I think the recommendation is appropriate. I think it recognizes your wrongful conduct in this case, provides a degree of punishment for you, so you understand that this kind of conduct is going to be dealt with seriously, and it recognizes your past incidents and past failure to correct yourself going forward. So for those reasons, the court finds the recommendation is appropriate, and the court is going to follow that. With regard to case number 236520, court sentences you to 12 months in the Otsego County Jail. You have credit for 8 days served. Crime victims assessment of $130, court costs of $325, and a $68 state cost. And file number 236521, 12 months in the Otsego County Jail with credit for 8 days served. A crime victims assessment of $130, court costs of $325, and a $68 state cost. In file number 236522, 12 months in the Otsego County Jail with credit for 8 days served. Crime victims assessment of $130, court cost of $325, state cost of $136. In file number 236523, 12 months in the Otsego County Jail with credit for 8 days served. Crime victims assessment of $130, court cost of $325, and $68 state cost. It's all run concurrent to each other. You do have the ability to seek an appeal of this sentence. Mr. Bardish, I just need you to have your client acknowledge receipt of.
You want for each case, Ron?
Yes, please. Mr. Alexander, and for custody of the county.
Thank you.
Okay, we're back on the record in People versus Ingersoll, and I do see where we have all 3 files up for today, so I apologize for that. Mr. Ingersoll is joining us again from Roscommon County Jail. We have both counsel present. So counsel, how did we want to proceed today?
Your Honor, thank you. I think Mr. Trush is back in front of you, but just in case he isn't, I'm not sure what's happening with the sound. As I indicated, I apologize if I'm shouting. I really can't hear my own voice right now. But Mr. Ingersoll is prepared to take the offer that was made by the city in this matter on all 3 charges.
Okay, so whether that's you, Mr. Trush, or Mr. Hallman, can you tell me, well, first of all, are there any files that are gonna be dismissed in their entirety?
Don't believe so.
Okay, so if one of council can tell me what the agreement is.
Would that be me? Sure. In file number. I just want to make sure. 6657. You would plead to. Added count 3, felonious assault. As a habitual second. And you would plead to count 2. And in exchange, we would dismiss count 1 and the habitual 4.
So does that added count come out to then?
It would be.
Six.
Oh, I'm sorry, you're asking for the MCL?
No, the maximum penalty for felonious assault is a bit.
Yeah, 6 years.
6. Thank you. Okay.
And I have to go file that file, so second.
In your honor, I think I could.
Go ahead, if you have it right there.
In the file involving the photograph, which I believe is 6704 FH, he would be pleading to use of a computer to commit a crime.
It's 6705.
6705, use of computer to commit a crime, and then in 6704, I believe he would be pleading to the obstruction of justice.
Okay, what's the maximum penalty on the computer charge?
That's a 1 year.
1 year misdemeanor?
Yep, and then the other is the obstruction is 5
Yes.
years.
So the status gets it, everyone gets it. In 6705, that's an added count 3. And in 6704, it's just. Yes. Okay.
All right, I think I got it. All right, Mr. Hallman, is that correct from your understanding as well? Mr. Hallman, you're muted.
That's my understanding, Your Honor.
All right, Mr. Ingersoll, have you been able to discuss this plea agreement with both of your attorneys?
I have, Your Honor, so I'm gonna be pleading to, so we're clear, it's gonna be a domestic violence, felonious assault, using a computer to commit a crime, and obstruction of justice, correct? And everything else is gonna be dismissed.
Yes.
Yes, Your Honor.
Okay. Can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. You can lower your hand. So in case number 246705, you're going to plead one count of using a computer to commit a crime. That's a 1 year misdemeanor. Do you understand that maximum penalty?
Yes, sir.
In file 246704, 1 count of obstruction of justice, that is a maximum penalty of up to 5 years and or a $10,000 fine. Do you understand that?
I do.
In file 236657, 1 count of felonious assault that carries with it a maximum possible penalty of up to 6 years. Do you understand that?
Yes, sir.
And then 1 count of domestic violence in that file, which is a 93-day misdemeanor and or a $500 fine. Do you understand that?
I do, Your Honor.
Counsel, are there any potential mandatory consecutive sentencing sanctions in this case?
I don't think there's any mandatory judge.
All right, thank you. And Mr. Ingersoll, are you currently on any kind of probation or parole that's going to be affected by this plea today?
I am, Your Honor. So, following the sentence, that comes from, this court, I have to go to federal prison on a, violation. So that will be as far as I know, that'll be a consecutive sentence. So I've got to do state time, and then, I'm going to be, put on an airplane and introduced to the, federal system.
Okay, I just want to make sure that you were aware of that. So it sounds like you are. All right. Okay, with all of those things in mind, Mr. Ingersoll, what is your plea to each of those charges that we've discussed here today?
I'm going to be taking responsibility for what was named off, Your Honor.
Okay, you're entering a guilty plea?
Correct.
So I'm going to go through your rights with you. Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. Do you understand all those rights?
I do, and I waive them, Your Honor.
Okay. Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal your plea, you'd have to ask the next court higher up, the Court of Appeals, to hear your case. If they said no, then you wouldn't be able to go any further with appealing your plea. Do you understand that?
Yes, Your Honor. In an effort to play damage control, I will not be appealing this case. Just try to get home to my kids as soon as possible.
All right, has anybody threatened you with anything to get you to plead guilty today?
No.
Has anyone promised you anything other than what we've said on the record?
Yes, that I will not be facing a state consecutive sentence, and the 2 felonies for the full will be dismissed.
Okay, so the plea agreement you're talking about that we discussed?
Yes, sir.
Okay. Outside of that, has anybody promised you anything?
No, Your Honor.
Okay. Is it your own free choice to enter this plea?
It is.
Are you pleading guilty to each of these charges because you are in fact guilty?
Yes, Your Honor.
Right, so Mr. Hallman, with regard to your file, which is the 236657, I'm going to ask that you conduct some questioning of Mr. Ingersoll to establish a factual basis for the 2 charges in that case, please.
You're sure. Mr. Ingersoll, you're aware of the charges against you regarding, and I'm trying to pull up the night in question right now, but on the night where it's alleged that you committed felonious assault and or other charges against your ex-wife, Cassandra.
Yes, we got into it. We started arguing.
Let me ask you a question. At any point during that night, did you make physical contact with her?
Yes.
And did you make unwanted physical contact with her, as in she did not consent to it?
Maybe in her drunken state she didn't consent to it, but yes. Kind of got me against the wall.
Well, and as we talked about, this, is part of the plea process in terms of taking responsibility, and we're just trying to make that clear for the court that you are taking.
I am not contesting these charges, if that's what you want to know. Like, I am taking responsibility for these charges, Your Honor.
Your Honor, are you satisfied?
Well, Mr. Hallman, you know, we haven't addressed really any of the elements, so. there
I'm
has to be a
sorry.
back-
I'm just having a hard time hearing, Your Honor. I have a double ear infection and it's just that you're muffled. I'm going back and forth with him. That's all.
Yeah.
If the court wouldn't mind conducting it, or Mr. Trush, I would be grateful. I'm just having a hard time hearing my client. I know he's been talking.
Mr. Trush, are you aware of the facts in this file?
I'm not aware.
Okay, hold on.
Your Honor, if I may, like you want, like, is the court looking for, like, me and my old lady started arguing? She picked up a bottle of lotion and hit me in the eyes with it because she thought some chick left a bottle of lotion in my house. So she started pushing me and she hit me and I pushed her off of me and I slapped her for hitting me. Like, is that what you're wanting to hear, Your Honor?
Yeah, did that happen on September 10th of 2023?
That sounds about right. Yes.
And did that happen in Otsego County?
Yes.
Okay.
Thank you.
And that was your wife at the time, is that correct?
It was.
Okay. And then Ms. Ruger, what's the felonious assault part of this?
Judge, he was initially charged with assault by strangulation. I think we were sort of treating this as like a lesser included offense to this for a factual basis. There were some allegations that he had strangled her. There are a number of other physical allegations in the report.
So at this time, Your Honor, I will be accepting responsibility for the charges.
You know, counsel, I don't know what you want me to do. You guys are the ones with the facts here, not me. So somebody needs to ask some questions to establish the felonious assault. I don't care who it is.
The answer is yes, sir.
I understand, but we need to have a factual basis, so there needs to be some testimony about exactly what happened between you and your ex-wife that would constitute a felonious assault.
Well, if you're looking for, so there was an argument that happened between her and her friend.
Your Honor, if I may, Nigel, at any point, whether you initiated the confrontation or not, did you at some point in an attempt to restrict your ex-wife from movement, put her in a sleeper hold of sorts?
I did, yes. It's called a guillotine. It's trying to separate a fight.
And the guillotine move was you put your arm around her neck?
I mean, that's how it's done. Yes.
Ms. Kruger, are you satisfied with that as a factual basis?
I am, Judge.
Okay. All right, thank you.
Are we-
Mr. Sullivan,
Okay.
Mr. Trush, going to ask you some questions about the other issues. Mr. Trush, your two files, please.
Thank you, Your Honor. Mr. Ingersoll, can you hear me okay?
I can.
Okay. On or around September 7th of 2023, were you here in Otsego County?
Yes.
And on that date, were you at home?
I was. Well, I went to the bar and work, but at some point during the day, I was at home. Yes.
And was your wife at home at that time as well?
We live separately. If you're asking if she came over to my residence, the answer is yes.
Okay, and at that time, was she on your couch?
She was.
Yeah,
and
was
I
she
took a
dressed?
picture of her.
Was she
I took a
dressed?
picture of her.
Nigel, slow
No.
down for a minute. Let me ask the question. And there's a little bit of a delay. Was she
Okay,
dressed
so-
at that time?
No,
Did you take a photograph of her?
I did.
Did you send that photograph to at least one other person?
I did.
I believe that would, And when you sent that photograph, that was with your cell phone?
It is correct, which is also considered an electronic device, which could be subcategorized into a computer. So I'm fine with that.
Ms. Bruker?
I'm satisfied with actual basis.
Thank you. Mr. Trush, obstruction charges.
Thank you. Subsequent to the assault, you were in the Roscommon County Jail, is that correct, Mr. Ingersoll?
And still here, yes, sir.
And you were there on February 20th of this year?
Been here since September 25th, yes, sir.
And while you were in the jail there, did you have conversations on the phone with, I think your then wife, now ex-wife Cassandra?
Yes, sir.
And during those conversations, did you ever discuss the assault case?
Yes, sir.
I think that, and there was a provision of your bond which required you not to have contact, correct?
Yes, sir.
And you knew about that provision?
Yes, sir. And I completely disregarded it. Yes, sir.
I think that would establish the obstruction.
Ms. Bruker?
I agree, Your Honor.
Okay. All right, thank you. Ms. Bruker, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
And are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Trush, as to your files?
I am satisfied there's an adequate factual basis. I believe the court has complied with court rule, and I am aware of no threats, promises, or inducements.
Thank you. Mr. Hallman, if you can unmute, and are you aware of any threats, promises, or inducements?
No, Your Honor.
Are you satisfied the court has complied with statute and court rule?
Yes.
So, Mr. Ingersoll, the court finds that your pleas are knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of each of these charges. The court will accept your plea to each of those charges. We're going to set this matter for a sentencing hearing. Mr. Ingersoll, you have the right to be here in court in Gaylord for that hearing. If you would like to exercise that right, I would sign an order to have you transported here for the sentencing hearing. You can also choose to have that hearing by video as we're doing today. Do you know how you'd like to proceed in that regard?
I would love to see some trees, Your Honor. Some fresh air, even for a second, would be wonderful.
All right, so we'll set this for an in-person sentencing hearing here in Otsego. Ms. Bruker, I'll ask that you prepare a writ to have Mr. Ingersoll transported here. And then Mr. Hallman, you will need to be here in person as well for the sentencing hearing, okay?
All right,
I got a question. In an effort to keep him from having to drive 3 hours, would it be easier if Mr. Hallman could do this via Zoom? That's a lot of time in his vehicle.
Yep, I understand, but for sentencing hearings, it's really important that the lawyers are here with their clients in case you have questions, so that he can help you with that, so.
I appreciate it, Nigel, but I'll be there. I look forward to it, and I look forward to seeing everybody at the court too. I appreciate it.
I just have one more question before you guys kick me out of this thing.
Yes.
Can we do a more prompt sentencing date than these dates have taken? I have a federal hearing on the 15th of May, and I would really like my state stuff to be concluded by then. That way I can get this show on the road.
So somebody from the Department of Corrections will be in touch with you for a pre-sentence report, and we'll get it scheduled as soon as that report can be prepared.
Thank you, Your Honor.
Okay, thank you. That's all for this hearing today. This also concludes the court's morning docket. The court will be in recess until 1:30.